sense of what we've seen in this trial so far. Let's go ahead and bring in federal criminal defense attorney and adjunct lecturer in law at Columbia University, Caroline Polisi, as well as former federal prosecutor and NBC News legal analyst Glenn Kirshner. Let's start with you, Glenn. We heard from members of the Minneapolis police force today, and the prosecution was asking them about, quote, the use of force. In fact, take a listen to what Lieutenant Richard Zimmerman said.
If your knee is on a person's neck, that can kill them. Once a person is cuffed, the threat level goes down all the way, you know, to they're cuffed. How can they really hurt you, you know?
Well, certainly there could be circumstances when a cuffed person could still be combative.
Oh, absolutely, yeah, yeah. But you getting injured is way down.
So what's interesting here is that Zimmerman called Chauvin's actions, quote, totally unnecessary and uncalled for. So legally, Glenn, how important was that moment?
Incredibly important, Morgan, because here's what happens when you're a civilian, when you're a juror, when you're somebody who has no real knowledge about police procedure and types of restraint that are appropriate or that are prohibited. You may see that video with your own eyes, as we all have, and be horrified and want to leap to the conclusion the police officers killed George Floyd. But some jurors might still hesitate and say, well, but I'm not really steeped in police procedure. What Lieutenant Richard Zimmerman just did, in a very real sense, is give them permission to convict. Why? Because he talked about the police procedure. He said specifically, you don't leave somebody handcuffed behind their back, prone, that is face down, because it makes it difficult for them to breathe. You get them up from that position and at least on their side as quickly as possible. So he answered the procedural question. He then said putting a knee on a neck is what we call top tier or deadly force. And then he answered the ultimate question. He said it in three different ways. He said the force was totally unnecessary. He said it was uncalled for, and he said it absolutely should have stopped at the moment George Floyd was on the ground in the prone position, handcuffed behind his back and not struggling. I think that should satisfy every juror who has no background in police procedures that what these officers did was dead wrong.
But the question, Glenn, is will it? Will it satisfy those jurors? Because Caroline Chauvin's defense team then tried to counter the prosecution by saying that sometimes unconscious suspects can become combative when they're revived, and the police officers then can improvise in these dangerous situations. So, Caroline, what did you make of that defense, of that counter argument?
Well, they tried to make it, but it fell extremely flat. I agree with Glenn that the testimony from Zimmerman today was just absolutely devastating to the defense, because remember, the way the prosecution has charged this case, they don't have to prove that Chauvin intended to kill George Floyd. They only have to prove one of the elements is that it was an unreasonable behavior to take. And Zimmerman there, he's the top dog. He's the highest you can get in the Minnesota Police Department. He is on the stand saying this was unreasonable. This was nowhere in police training are you authorized to use this level of force in response to what George Floyd was doing at the time. And so really the defense did not give the jury the authorization to really move forward or believe that defense, that somehow, you know, there are no rules with respect to how police go about engaging in their job if they feel threatened. It just doesn't hold water anymore.
Well, I appreciate what you said about, you know, reiterating that they really must prove unreasonable behavior, which is why I want to go back to something you said earlier, Glenn, about those jurors, because my colleague Shaq Brewster reported just earlier today that jurors were taking notes during these moments from police officers. So if you're a prosecutor, what does that tell you? Does that give you any indication of how they're leaning or how even that particular testimony impacted them?
Reading the body language of your jury, which I did for 30 years, tells you so much. Frankly, it tells you a lot, not only about what the jurors are focusing on and what they're dismissing, but it does key you into where you might want to, focus some of your closing arguments. I have seen so many times that when a defense attorney starts to cross-examine a witness in a way that either falls flat or even worse, alienates or upsets some of the jurors because the way the defense attorney is treating the witness, you will see them cross their arms, put down their pad and their pencil, and lean back. That's a sure signal with their body language that they're not buying it. So the fact that they were not only keenly interested, but taking notes about those police procedures as the police witnesses were testifying tells those prosecutors they're on the right track.
And just before we let you guys go, Caroline, we talked earlier about the burden of proof. And let's just be clear here, the burden of proof is on the prosecution. So where do you think they left the jury heading now into the second week of trial?
Look, they left the jury in a pretty good place. Look, there's no denying this is their case at this point. We'll see what the defense has to say in terms of putting on its case. I think you're going to see a real shift in the defense. They're going to try to hammer home the causation element because they're not really winning with respect to the reasonableness element. So I think you'll see a big emphasis on medical testimony, medical experts testifying that maybe it wasn't actually the knee to the neck for 9 minutes and 29 seconds that actually caused George Floyd's death, but maybe there were more substantial factors like, as we've seen already raised in this trial, potentially his prior drug use, what he was doing that day immediately preceding the incident. So I think, they have to use what they have, and you'll see a shift in the emphasis on that causation element.
Caroline, Glenn, we appreciate your expertise, your experience, your analysis. Thank you, and we hope to talk to you next week also as that trial continues. Thank you so much for being with us. And for the rest of you, stay tuned. You're watching NBC News Now.